we're going to go to Cheryl Bader, who's a law professor at Fordham University, and also, hello Cheryl, also a former assistant federal prosecutor in the District of New Jersey. Your reaction to this indictment for the former president?
Well, as was said, this is just unprecedented, and I think we're going to see a lot of, trying to figure out what's going to happen next in a case where a president has been indicted. And I think we're going to have a lot of uphill battles for Bragg. He has to not only establish his procedural hurdles to overcome. For instance, there's a statute of limitations question here. There's also substantive issues of law, because in this particular case, normally the charges, and of course I should start out by saying that we haven't actually seen the indictment. It hasn't been unsealed yet, so we don't know what the precise charges are. But the speculation is that this involves charges of recording business records and actually secreting the fact that hush money payments were made to Stormy Daniels. And normally falsifying business records is actually a misdemeanor charge. But we know that if the grand jury is issuing an indictment, that a felony is being charged here. And so there has to be sort of a piggyback onto another charge.
You spoke earlier, Cheryl, about the grand jury, and let's just get into it a little bit more so people understand. This is different than the jury sitting in a criminal or a civil trial where we either see it on TV or not. This is a grand jury, a selection of your peers, 23 different stuff on the numbers, how many are asked, but still needing 12 to vote, no judge in the room. Can you describe that process? Because this has gone on for several months now. What's the process for the DA and the jury members?
Yes, the grand jury, grand meaning a larger number of people, the grand jury is actually an investigative arm of the prosecutor's office. And so it's a secret process with just the prosecutor and the grand jurors in that room. And they are there to develop the evidence, so to subpoena documents, to hear witnesses, and they're really actually also a check on prosecutorial discretion. So to make sure that there actually is evidence going forward before someone is charged with a crime.
We know that as far as people who were called in to be questioned, and some a couple of times, let's talk about the significance of the former editor of the National Enquirer, David Pecker, who was, I believe, the last person called in to testify. And that was, what, Monday, just a couple of days ago? Talk about that and that they voted today, how you see it from a prosecutor's eyes.
So I think there's a few things going on here. One is that Bragg has to establish that there was this other election fraud crime going on in order to elevate it to a felony. And so that means that they have to establish that Trump actually knew that this hush money would be important for his campaign. And that he was hiding the fact to, in fact, further his campaign. And so, this witness can talk about the fact that they discussed, right? He and Michael Cohen had discussed that, it would be bad for the campaign in the upcoming weeks for this to come out. And so that, that Trump understood that and that everybody was on board with making this payment in order to further the purposes of the campaign. The other thing is that, a lot of, look, the defense is going to make hay of Michael Cohen, right? He's a flawed witness. He, has been convicted. He's changed his story, right? So it's so important to have corroborating evidence. And so, this can give corroboration from someone, who is, doesn't have the same, potential motives to lie that the defense are going to bring out.
The process now, and there's been a lot of speculation, just because it's still a shock. Here we have a former president indicted indicted. Just how this process could move, it's worth saying again, versus how, we're used to it moving, of when you're getting word of a surrender, which door he goes in. Can you talk about that?
Right. So we have the legal process, and then we also have sort of the political fallout and how those two intersect. And so, I agree that, he's going to come in the back door, and they're going to try to make this as dignified as possible. First of all, whenever you have what we call white collar crime, there is always going to be a more dignified process than, the clients that my students that I represent. And unfortunately, that's one of the racist aspects of our system. But I think especially in the case of a former president, you're going to see kid glove treatment. On the one hand, some people are speculating that Trump wants to come in and do the perp walk, and that this will actually galvanize his supporters. But I'm sure that they're arranging for him to come in, with his entourage of Secret Service agents, and to make this as seamless as possible.
I got to ask, if he says he wants that, security obviously a top issue, but do you think that could happen? Him walk?
I don't think people get to pick.
No, right? I
don't think people get to pick. I want. Bring on the circus, and
I know.
Let me play the political witch hunt victim. So I would be surprised.
We're looking at a live picture of Mar-a-Lago, where the president, former president, and First Lady, the residence there, which has been part of a whole nother investigation by the Department of Justice on accusations of document issues. We know that the former president knows there's been an indictment. How long, on this unsealing, who decides when an indictment is unsealed? How does that part work?
Right. So the prosecutor decides about unsealing it, but I'm sure they're making arrangements for him to surrender, and I'm not sure what that timing will be. I think there's also going to be timing issues around these other indictments that are, potentially coming down against him. And it's a long process, right? We have discovery, he'll start out with an arraignment, it'll come before the judge. That just starts the process. There's going to be exchange of discovery, particularly, coming from the prosecutor to the defense. There's going to be extensive motion practice here. I think, statute of limitation motions around preemption, federal preemption, motions to dismiss based on this sort of convoluted piggybacking crime, and then, of course, prepping for trial. So I think we're going to see a long process here.
Cheryl Bader, thank you. Please stick around for us. I can't imagine the discussions you're going to be having with your students, witnessing history in the making. Thank you. Thank you very much. Let's go.
Thanks, Dana. It's good to be here.
You're welcome.